He'd realize it's germane.
It being 7 o'clock,
Thank you.
the regular meeting of the zoning board of appeals of the town of Orleans is called to order. Present are myself, Michael P. Marnick, who is the chair of the zoning board of appeals. Also with me are William McCarthy and Emily Van Giesen, Gerald Mulligan, Peter Jablon, and also Bruce Todd. A quorum is constituted. Also present are Sandy Stewart, board secretary, and the building commissioner of the town of Orleans, Tom Evers. The housekeeping, I am reminding all those present of the event conducted by the Cape Cod Commission on November 8th at 6:30 at the Council on Aging, which will be actually the second Community Resiliency by Design workshop. That study is evaluating building type, scale, and design to meet community housing needs in the future. There was a survey, at least 2 of us, and maybe more, responded to the survey, and I've been asked to circulate this message to the boards, and so therefore I've done that. Now, also, it would be in order to review and approve or comment upon the minutes of the last meeting, which was September 19th, 2018. The minutes have been circulated. Is there a motion to accept the minutes? By Mr. Mulligan, is there a second?
Second.
Mr. Jablon, any discussion on the motion? All those in favor?
Aye.
And opposed, motion carries unanimously. Tonight's business consists of 3 cases. The first of which is case number 2069, which is the a modification of plans of the roof line on for F. Naomi Weinberg and Edward Burke. This property is located at 16 Haywood Lane, Orleans, map 50, parcel number 4. Is anyone present to present this? Members of the board, the case number 2069 resulted in a decision to grant a special permit dated October 4, 2017. There were site plans presented at that time, and on the letter of September 28, 2018, there were what were proposed to be minor revisions. We'll see how minor they are. Do you want to tell us about it?
Sure. Yeah. So for the record, Aaron Paulhemus Saber de Silva, and here with
Aaron Udvardy with Paul Hemus Saber de Silva.
So we do believe the changes that are being proposed are quite minor, and we're here to present them to you this evening. So Aaron will take a lead. I can hold this up, and you can run through.
So as the original scheme that we had submitted is on the upper part of the line here. What we're proposing to do is at the pool house area, lift this roof line up a bit, just to simplify the roof condition as it wraps around. Currently, the way it was designed, we have a breezeway, and then it ties into a lower roof and also this gable end roof. In order to simplify that, we've created just a gable end, which really simplifies that roof and that condition and avoids having a cricket for this original layout, and just simplifies it. In doing so, it does raise the roof up at that one area,
but still well below the the roof line of the house.
What is the actual increase in the roof line? There's no measurement shown there.
yeah, it's approximately 2.5 feet.
Very well.
Yeah.
there are other,
Couple other
Yes.
small
Yep.
changes.
couple of
Again,
other,
That's part of it. And then at the front entry, we're looking at just modifying this front entryway. Currently, we have shown transom units at the front entry, which kind of align with the windows. In order, again, just to simplifying this front entryway and increasing the door in height, we've removed those 3 transom units and on the 2 on the side, and are just simplifying it again, just having the 2 columns in the front and then the 2 columns on the side. Fairly simple modification. The third one is on the original scheme. This is really at the kitchen area. We're looking to add windows, currently where there's no windows here in this corner, and adding the 2 windows down
Windows.
here. Again, fairly simple change, but not as necessary.
any questions? Board? The zoning bylaw doesn't design what's a major revision or a minor revision. That's why I asked you to explain. We could conclude that these are minor revisions. Is there anyone else wishing to speak concerning this application for approval of the revised plans? There's no positive response, therefore I'll declare that the hearing is closed, and I would entertain a motion to approve the plans entitled Pool House, page A-2.0, dated September 26, 2018. The plan entitled North and West Elevation, page A-2.1, dated September 26, 2018. And the plan entitled South and East Elevations, page A-2.2, dated September 26, 2018.
So moved.
Is there a second?
Second.
Is there any discussion on the motion? All those in favor
Aye.
and opposed? Then there's no opposition. The no opposing vote. Motion carries unanimously.
Thank you.
Thank you.
Thanks.
Today's October 17. You'll have to designate who didn't vote. 6 of us. For clarity, Stewart, for clarity, I am designated on that application the following members to have considered it. Mr. Jablin, Mr. Mulligan, Mr. Taub, myself, and Ms. Van Giesen. The vote was unanimous, and those named members all voted in the affirmative. Does that do it? Okay. Members of the board and those present, We have the case number 2097. This is the application of Latanzi, Spalding, and Landreth for a modification of a previously granted variance as set forth in General Laws, Chapter 48, Section 10, under Orleans zoning bylaw, Section 164-35, to display a large or off-premises sign. This property is located at 8 Cardinal Lane, Orleans, map number 25, parcel number 54. This case was when was it? Oh my gosh, it was a long time ago. It wasn't an art. Very well. 97, very well. Following members will consider this application, all of whom will constitute a quorum. Ms. Van Giesen, Mr. Jablon, Mr. McCarthy, and myself. Is there anyone, a member of the board, who's had communication with the applicant or any of the applicant's agents, which would ought to be disclosed to the public or otherwise constitute a conflict of interest? A positive response. Therefore, I declare that the members of the zoning board is constituted and to conduct this hearing are indifferent and impartial. Mr. Landreth.
Thank you, Mr. Chairman. For the record, my name is Dwayne Landreth, and I'm here appearing on behalf of the law firm Latanzi, Spalding, and Landreth. The relief sought is modification of a variance which was granted in case number 1079. The variance was required because the sign is an off-premises sign. To understand the geometry, I provided for you in the application and narrative a copy of the subdivision plan of April 1985 that created the subdivision. It is Exhibit B to the application, and I would simply ask you to look at it. As you can see, it's a 3-lot subdivision. Let's get it true north, which is subdividing property abutted by Locust Road and Main Street. 3-lot subdivision with lots 1 and lots 2 located on Main Street with frontage on Main Street. A subdivision way on the southeastern edge of the property for lot 3, which is 150 feet down that cul-de-sac and results, as a result of the scope of the building, in a front door that's approximately 300 feet from the street. Incidentally, Lot 2 is property owned by Pike Insurance, which has written a letter in this particular matter. Now, I ask you then to look at Exhibit E, which focuses a little more closely on the location of the existing fence. And it's here, it's X marks the spot on Exhibit E. This is an approximate blow-up of the other plan, though it's not taken from it. It's a slightly different plan. That location where the X is 10 feet off of the traveled surface of Main Street. The way that's shown on the subdivision plan is designated as Cardinal Lane, and as the chairman indicated, the address of the law office is 8 Cardinal Lane. What it essentially is, though, is that the cul-de-sac comes in on a driveway that leads to the office building. That's the only building on that property. So Cardinal Lane, rather than functioning as any kind of a way at all, essentially functions as a driveway for the law office. Since the original sign saw it was approximately 5.5 feet by 1.5 feet, that's what it says on Exhibit B, where it refers to proposed sign. That was knocked down by the Zoning Board of Appeals in 1988. So Exhibit I would ask you to look at. It is an it's a black and white photograph, Exhibit I.
I don't have it in.
All right.
I don't either.
Okay. I think just pass it by.
Thank you.
I have a copy of the story the other end.
Okay.
All right, so that shows the sign. It shows that it's backed up by a Nantucket fence. The sign is 4 feet wide by 1 feet tall. Behind it and above it are 18.5 feet, or 18 feet thereabouts, worth of ladder signs that all pertain to the Pike building. So that's what it looks like in sight. I've also prepared a little photographic essay to show you traveling toward the law office on Main Street as to what you see, and showing you the entrance from the street, which is 21 feet wide, what you see of the office building, which is essentially nothing, and then also a picture of the buildings itself once you get back to them. In the first picture, you'll see the sign just to the left of the electrical pole in the middle of the photo. I'll just get these going. Start with Mr. Taub. They're in order. The following photos will show you the approach to Cardinal Lane and, as I say, a view of the office building once you are on Cardinal Lane as it turns off of Main Street. Perhaps it would advance things if you could just pass them along. As you look at one, pass it along. And
Very well.
some of it, it's somewhat duplicative.
Okay. The height of the present sign is 18 inches.
No, I believe it's, yes, I think it is 18 inches off of the ground as I look at it, yes.
You're looking to substitute that sign.
Oh, no, I'm sorry, Mr. Chairman. The present sign is approximately 30 inches off of the, and then what we're going to do, and you'll see it on Exhibit J, if you look at that, that shows where the proposed sign is. It's essentially going to be at the same height that the present sign is on the fence and going further down toward the ground. So the fence is, the sign is just about at seating level when you take into account the elevation of Main Street relative to the elevation of the ground there.
The dimension of the present sign is 48 inches by 18.
No, it's not, Mr. Chairman. What
is
are you looking at?
the height of the present sign, Mr. Landrith?
No, it's, the height, the width, 4.
That's okay.
The height, 1 feet.
It's 12 inches,
Yes, 12 inches.
and you're seeking to substitute that with the sign, which is with the beacon on it, that's 24 inches high.
Yes, exactly. And that's shown, just to make a comment about those photos, they illustrate that the building is virtually invisible from Main Street, and that a 1 foot by 4 foot sign is completely inadequate to direct a motorist to the site. As I noted in my narrative, 5 of the attorneys of the 15 that practice in the law office at this point deal with elder affairs. And since 1986, I've been listening to their, or 1988, I've been listening to their grumbles about this particular problem.
It's not an ageist remark, is it, Mr. Lynn?
Well, no, I'm part of the protected class. You can't have an ageist remark under those circumstances.
Majority of the time.
So I think that shows visibly what we're trying to accomplish under these circumstances. If you look at Exhibit J, which is the new sign, page 1 and page 2, you can see that the proposed new sign, as it would be seen from that distance away, is not exactly overwhelming. And in fact, it does a little better job of competing with the Pike sign than this one, but not that much. The fence features the logo of the firm, which is not presently displayed there. The white portion of it is to be carved, and the lettering of the firm will be the same color as the lighthouse background. The beacon is lemon yellow, and the sign background is beige. That color scheme is carried forward on the 1.5 foot by 2 foot directional sign on the left-hand side of Cardinal Lane, which is on page 2. That's right at the entrance, or beyond the entrance to the Pike Building, which is off of Cardinal Lane. And the third sign is the 11 by 11 inch by 26 inch sign that's at the front door, which utilizes a slightly different color scheme because of the fact that it shows up better against the beige of the shingling. As is required by the Architectural Review Board, the sign was presented to the ARC last Thursday, and it voted to approve the sign. I'm going to hand in a copy of this. Actually, I'll give you 3 copies so you can share it to the extent that you need to look at it.
Oh, thanks.
You need to see this anymore?
Let's see.
Now, for clarity, this application doesn't deal with the the sign with the arrow. So you don't need any.
No, that's by right.
You don't need any permitting for that.
That's correct.
And you don't need no permitting for the sign on the,
That's correct.
at the entrance to the,
They're essentially replacements and within the required dimensions that called for on the,
now what you propose to do is to change, add some landscape, 3 trees, and you propose to replace the present fence with a fence that's curved and perhaps longer and more graceful than the present fence?
no, sir. We're not planning to replace the fence. we're not planning to put those trees in. That site plan I utilized simply because it showed the present location of the fence and sign and was scaled.
All right.
So there's not going to be any change in the fence at all, merely a larger sign at the same eye level as the top of the current sign, 12 inches further down toward the ground, as looked at, as seen on page 1 of Exhibit J.
So this was actually 88 plan, you're just. for
It's an 88 plan. I wanted to save a few bucks.
All right.
Now, the report says that we could also do this rather than with a white fence, with a blue fence that was painted the same color as the blue on the sign. And we did a test of that, and I don't want to tell the Architectural Review Committee how it looked, but let us say that we prefer the white. It's not going to stand out quite as much as a blue fence would.
So it compete with your logo in the background?
Yes, yes.
And yet, they seem to suggest that they want it to be the same?
They wanted it to be that blue color.
But that picket fence has been white ever since
Yes, sir.
for many years.
Well, it's a little bit like giving a piece of work to a lawyer to review. The lawyer will have to take a crack at revising it, otherwise they don't feel like they're doing their job. So I appreciate the point of view of the Architectural Review Committee. I was very excited about it until we mocked it up, and it, unfortunately, it makes the sign disappear, but you certainly get a good look at the blue fence.
And it's only a suggestion as opposed to.
It's only a suggestion. I asked them to put it in the alternative because I was negotiating with the partners of Lattanzi, Spalding, and Landreth. I didn't have authority to change it. All right. The legal argument is that it's essentially the same standards that you need to use when you first grant a variance. A modification of a variance can be obtained if a literal enforcement of the bylaw would result in a substantial hardship to the applicant, and the hardship relates to shape, topography, or soil conditions, which conditions specially affect the subject land or structures, but not affecting generally the district in which it's located. And desirable relief may be granted without substantial detriment to the public good or derogation from the intent and purpose of the bylaw. Now, in its 1988 decision, which is reproduced, the board decided that there was a business hardship with regard to clients locating the office, and the hardship was caused by the shape and location of Main Street, of the land in its relationship to Main Street. The photographs that I showed from Main Street aptly illustrate the problem and illustrate that the sign needs to be more prominent than at present. This is a unique condition in that this small business district, there are signs of business in the vicinity of the buildings which are all visible from and located on Main Street at approximately the same distance away from Main Street as our proposed sign. But these buildings all front on Main Street, and I'll show you some photographs that illustrate that particular fact, and show you the signs that are around.
Just curious, if I may, as they're being passed, you go into what I think your objective is. Just any thought given to an arrow on that fence sign that sort of directed clients into it? Or?
No, the arrow would take up space on the sign that we need to display the information of the firm. So that was considered and rejected. I mean, if we had a 10 or a 12-foot sign, or 15-foot sign or 16-foot sign like these signs that you're seeing, we could do that. but we didn't want to be greedy.
And sort of the point is that all the signs that are on the standing post are on Main Street immediately off where the.
Yeah, they're essentially set back from Main Street, exactly the distance that our sign is set back. But the building is right behind it. And in fact, Pike Insurance, which has a few words to say about this particular zoning matter, you will see that they have a big sign on their building, big sign on the face of their building. So they couldn't apparently depend on the sign that's on the street.
Of course, they're right on Main Street, too.
Yes, and so is McIntyre and Friedman and Snow's, and so, yes, I that's a unique circumstance, which is we're back in the weeds.
And then there's another marquee further down the road with signs of 5 other business organizations.
Yes. And I noted this in the narrative, but the thing about this particular stretch of road is that people who are traveling along it, they feel like they've just gotten out of the clutter of downtown, and they tend to accelerate. So that it's, even though it's a 30-mile zone, it's not really respected all that much.
Is the logo new to the firm?
Yes, relatively new. It's what prompted the new sign. I'm not sure I said that the white is to be a carved feature on that. This relief will not threaten the public good. The sign is attractive in design and proportionate in size to the others you see in this area. With respect to the zoning bylaw, one of the sign code purposes is to facilitate the smooth and safe flow of traffic. To the extent that this new sign helps people get to our building, to find the office building, it helps traffic conditions. I would note, I'll just make one note concerning the decision in 1996. It was a 3-2 vote. One of the members on the board at that point in time, well, I won't comment on that. At that time, the board specifically found that conditions had changed, but not enough to change to overcome the intent of enforcing the sign code. In the 21 years since that decision came down, conditions have continued to change, and in that there's more traffic generally. The firm has grown almost twice its size from 1996, and it's more heavily used. I also I think that the decision in 1996 was flawed on its merits. It was a 3-2 decision, and I felt that, because I handled that hearing, I felt that it was a symbolic decision in the sense that the sign code had some aura, some presence that didn't allow it to be varied in that case.
That's a curious question, since the 88 one saw the hardship and granted the relief. What was it that they didn't find that?
Well, they wouldn't allow us to enlarge the sign.
They didn't think there was a difference?
We were seeking a modification at that point. They said, we see your point with regard to the decision is there. It says, we basically see the point. You're right, conditions have changed, but we don't have a consensus of the board. Some people felt that the sign code had to be upheld. So, that was it. It was not necessarily, in my opinion, weighing the hardship in terms of what the hardship was relative to I don't think it used the proper criteria. We were looking for a slightly different sign at that point. I think it was in excess of 8 feet, But 8 feet was what we saw initially in
The
1988.
traffic study committee allowed you to have an 8-foot sign. That's what you, 8-square-foot sign.
Yes,
That's what you want now.
yes.
But the original decision of the zoning board was
Knocked it down to 4 feet.
down to 4 feet. We don't have to worry about the design of the sign, just the size, is that
Yes,
right?
yes.
So, very simply, are you entitled to a modification of the variance to either, depending on where you want to get, double the size of the present sign, or to make a minor change in the sign, increasing its size? That's the very simple issue in front.
Yeah, well spoken.
So,
I do have one comment. I was handed a letter from Pike Insurance Agency when I came in tonight. Apparently, it came in at the last minute. Quite honestly, the letter basically does not go to the merits of the petition. It's basically a statement saying that they're upset about the fact that we didn't have the courtesy to notify them of the proposed variance, and therefore they oppose it. And I would say that the reason that I did not do the normal courtesy, which I didn't do to any of the neighbors in this case, because we truly are neighborly, is I couldn't imagine that this change in the sign would have any impact upon the Pike building. I refer to Exhibit J. I mean, I would argue on the edge of things that even though they're in a border, perhaps they don't have standing. But I'm sorry that Donna Pike feels that way, but I don't think that her letter has merit.
Did you say, in your opinion, they don't have standing?
I say you can make a colorable argument that they don't have standing. I don't see what harm that they're going to suffer as a result of this. And that's, you have, even though it's a very tough presumption to get over, you know, on a butter not having standing, but it has been done. And as I say, what impact is this going to have on her and her building?
Mr. Lander, could I see the letter?
Sure.
yes, you may.
Oh, I'm sorry.
I have it, Mr. Jablin.
Oh, okay.
It was in an envelope.
All right.
It's an undated letter.
Ask one question, please.
Yes, Mr. Todd.
As I looked at the map, is the fence on Lot 2 or Lot 3?
The fence is on town property.
Is on town property.
Yeah, if you look at the background to the earlier cases, we had to go to the Traffic Study Committee. We had to go to what they call the Site Plan Committee, which was doing the job of the planning board at that point, or the job of the site plan review at that point, or, no, I'm sorry, planning board at that point in time. And in that information, it indicates that the selectmen had granted us a revocable license to use that particular location, and it ran by all those committees, and they approved of it. They also approved of it in its original form of 4 feet, which was it was 4 feet, but it was a slightly different configuration than we're asking for now.
And technically, does the town own the fence?
Well, that's, the town certainly would have the authority to pick up the fence and move it out of there,
Okay.
yes. But it's, technically, we paid for the fence and we owned it, and we own it, and we were there with right, not a right that we could have forever if somebody wanted to get tough about it, but.
Let the record reflect that the abutters, those property owners within 300 feet of the applicant's property were properly notified as required by statute and the zoning bylaw. So, The letter,
Mr. Chairman, if I may also comment from the standpoint of neighbors, there has been some traffic before the Zoning Board of Appeals and other town boards in the area, including Snow's with regard to the project that they came through, in which we've received notification of it. And in all cases that I'm aware of, us and any other neighbor has never raised an objection. As I say, it's a true neighborhood, so I'm upset about Mrs. Pike's feelings, and I think she must not be in a good way.
well, we can't say anything about that, make that kind of conclusion, but the letter states, and I'm summarizing, that as Donna L. Pike, as president of Pike Insurance Agency and trustee of Kimberly Realty Trust, that appears to be the owner of record of 8 Main Street, which is appears to be, as of the sign of 1, 2, 3, 4 businesses, is entitled 8 Main Street.
That's lot 2 on the,
Yes, sir.
Yeah, she states in part that we have granted 2 variances, one in 1988 and one in 1998, have allowed the law firm to use their parking lot for their Christmas parties in the recent construction project on their property. Yet as neighbors, they didn't see fit to advise us of the new variance. New paragraph, the reason they have given is competition from the attorneys in our office is not credible. 2 single attorneys, one verging on retirement, will not compete with several attorneys in a long-established office. Years ago, there was confusion on the part of some of their clients as to the location of their office. In recent years, we have no clients from their office at our door. That is the summarized letter.
Can I say something at this point?
Yes, you may.
I work for Mike Flores on the other side of the driveway.
Yeah.
And I do have people show up looking for Latanzi Spalding and Landreth.
All right.
Probably once a month, somebody comes in my door looking for Latanzi Spalding and Landreth. And I have to say, no, it's the next driveway, they're
It's
back
not one of the
behind
named
us.
partners, is it?
I'm sorry?
It's not one of the named partners.
No,
Mr. Spalding or Landreth.
no.
Bad joke.
So,
Bad joke.
I was gonna say, Sandy, you're not doing much of a job if you can't keep them in the building once they
No,
come
no,
in.
no, that's okay.
generally speaking,
can we
as,
help you?
generally speaking, we, have an informal policy that encourages applicants to speak with the butters, but Ms. Pike complains that the law firm did not speak with her, but the law firm had absolutely no requirement to do so. This application was present here for inspection in all of its detail and exhibits, and is anyone present from Pike Insurance Agency here tonight? Is there anyone opposing this application tonight? So, I see some reasonable people would see no harm, no foul.
Further, Mr. Chairman, the letter doesn't state any harm or detriment as the cause of their objection.
No,
It doesn't go to any of the issues that we have to.
no, I didn't hear Mr. Landville talk about any competition with any lawyers on 8 Main
No,
Street.
when the Pike letter doesn't
Hmm.
state any reason that they would be harmed or by the expanded sign.
I didn't see it. Certainly, Pike Insurance and the law firm are not in competition with each other. Even if, then that wouldn't necessarily be a legitimate objection.
It's not even alleging that.
Are there any questions by any members of the board?
Just one question. It's hard for us to envision it here, but it looks as though the amount of signage standing above yours that say Pike Insurance Agency and Pike Properties is at least, appears to be at least 4x2. Maybe even be larger than 4x2.
Well, I looked at it and I just simply scaled it as being approximately the same distance because they are, and looked at ours as 4 feet. And then I thought it was somewhere near 16 feet worth of sign, because, you know, the sign covers, you have to enclose the sign. So if there's a little pedestal on it, that's the top, and then there's a square from there. So I
Just
don't,
their portion of the square, just their portion of the sign seems to be at least as large as you're advocating or asking for.
well, if we were having a beer, which I'd love to do with you all sometime, I would tell you a story about that sign, but it's not appropriate tonight. Let's just say that it's ironical that, I mean, I didn't go to the building inspector to see if there were any problems with any of these signs, and so that I could come in here and argue that.
My point poorly made is that even your expanded sign would in no way overwhelm the Pike sign.
No, I think it remains pretty visible, and I commend them. I think the black and gold is good from the standpoint of visibility. I'm not looking to compete with them, just,
Chairman, I would move to grant the variance.
Is there a second? Second. Any discussion on the motion? Mr. Taub?
I'm just looking at the sign permits portion of chapter 164 and the zoning regs, and want to make sure that we are in compliance with that. I'm not that familiar with it, but I wonder if Mr. Landreth could illuminate that.
well, as I understand the procedure, one must apply to the building inspector in the first instance.
Yes, I saw
I
that.
applied to the building inspector in the first instance and was referred to first the ARC. Well, actually, I knew I had to go to the Zoning Board of Appeals. When I came in with the Zoning Board of Appeals application, I was reminded that I needed to get by the ARC, which I did. So there is an application, an extant application, that the building inspector who's here tonight can acknowledge that it was properly filed in advance of coming to this board. And if the relief is so granted, then that I will be asking him to fulfill exactly, they're all consistent. Same size of the sign, same location.
I'm comfortable.
Very well. Then we'll call the vote. All those in favor?
Aye.
And opposed? Motion carries unanimously. Mr. Landreth, what do you propose that the zoning board ought to do or compose a decision?
If you want me to take a crack at that, Mr. Chairman, and submit it for your consideration, I'll be happy to do that.
This appears to be, it's all under the variance component of the zoning bylaw, and I think we'd all appreciate that if you could.
I'd be pleased to do so.
Very well.
And then it's simply issued exactly the same way the original variance is, and goes to record and can't be acted upon until it's gone to record.
Right. But that would, what is it?
I make one suggestion, comment for that unless I was missing it just in mind. I think since you're referring to
Exhibit J,
what it says, is it I or J? Because
it's,
mine stopped with H, so.
oh, okay, it's J.
Okay.
I think what happened, excuse me, some of them are not labeled because they came into my office in 2 batches. As it is whenever you send a job out for printing, you know, first time you don't get enough. And so the first ones were marked and the second ones weren't, and people kept taking the signs away from me, so it's J.
Okay, so you want to.
But I will definitely verify that with regard to the original application that I kept in order to maintain its integrity.
Oh, okay.
Very well. In electronic form, if you please.
Very good. Thank you.
Thank you.
Good luck with your Christmas parking.
You're gonna be in the street. Christmas. This is case number 2098, the application of New Venture Holdings LLC for special permit is set forth in General Laws, Chapter 48, Section 9, and the Orleans zoning bylaw, Section 164-31, for variances set forth in General Laws, Chapter 48, Section 10, under Orleans zoning bylaw, Section 164-34-3, to construct 7 two-bedroom apartment units in 4 buildings with associated landscaping, parking, and curb cut. The property is located at 1418 Cove Road, Orleans, map number 34, parcels number 4 and number 5. Let the record reflect that regular member of Emily Van Giesen excused herself for consideration. Therefore, those of the following members remaining, Mr. Todd, Mr. Jablin, Mr. Mulligan, myself, Mr. McCarthy, will call constituting a quorum, will consider this application. Has any member of the board so named have any communication with the applicant or any of the applicant's agents which ought to be disclosed to the public or would otherwise constitute a conflict of interest? There's no positive response. Therefore, I declare the zoning board as constructed, as constituted in this hearing, is indifferent and impartial. You may proceed.
Thank you, Mr. Marnick, and good evening to everyone, and Sandy, it's nice to see you all again. It's been a while. My name is Ben Zender, and I'm here with Paul Van Steensel, who's the principal of New Venture Holdings. And we're waiting for David Little. He's upstairs with the selectmen, and hopefully he'll join us. If you have any technical or engineering type questions, I'll probably defer those to Mr. Little when he's available to step into the meeting. I hope you don't mind. This is an application for both a special permit under your revised apartment bylaw as well as a variance from your parking requirements for the removal and reconstruction of the property at 14 and 18 Cove Road to build 7 two-bedroom apartments under your new apartment bylaw, which was approved at your May 8, 2017 annual town meeting. And that bylaw essentially changed the density requirements for apartment development so that in the VC district you were allowed to have 10 dwelling units per acre, and on a prorated basis, when you take the lot area of this property, which is 37,838 square feet, you're allowed to have actually 8.7, but we're proposing 7 units. So what we've presented for consideration by the board are 2 plans prepared by Ryder and Wilcox. One is an existing conditions plan which shows the location of a commercial building on the north side of the property. You may remember that as the Phoenix Fruit Building. Then there's a front building with offices and apartment. That was the old Cape Cod Times building. There's some legal offices in there, and then in between there's a small building which is a flower shop. The proposal would actually have a driveway reconfigured. 2 curb cuts on the south side are being removed, and a single curb cut off of the public road, Cove Road, is going to essentially run up to the center of the property. And then there will be 2 units on the southern boundary on Cove Road, 2 units on the northwest part of the property, and 3 units connected on the right side of the property. You'll notice in looking at the plan that there are connectors between apartments 1, 2, and 6, 7. There's a connector between apartment 3 and apartments 4, 5. And the reason for that is because your zoning bylaw defines apartments as being 4 or more units in a structure, and so we were able to go to the Building Code Board of Appeals, obtain permission for connector structures of a fireproof design, which connects the 2 buildings on the west side and the 2 buildings on the east side, so that we are compliant with your definition of what an apartment is in the town of Orleans. We have prepared and submitted for your consideration a narrative, which I I am hopeful with the chair's consent, I will not repeat and go through every standard of the narrative that's been presented. I'm sorry, the bylaw is 3 or more units, not 4 or more units, so we comply with that. So the requirement for the special permit granting criteria under your apartment bylaw, we've provided written narrative responses to each of the requirements in our narrative, as well as the special permit granting criteria of 16444 generally as well, which I would ask that I not read again in addition to the submitting. Additionally, we are asking for a variance from the parking requirement. Your bylaw 164-34-3 requires a minimum 10-foot setback from lot line to parking areas. We're requesting a variance allowing 6 of the 21 proposed spaces at the rear of the property to be allowed to be within 1.75 feet. That side of the property is already developed with that's the cut through where the bollards were that you saw. You may have seen as you saw the site. It's already improved with pavement and some building. And that would allow us to locate the parking area to provide the number of spaces that are required. The property narrows at the back such that in order to locate these buildings as required to meet the connection requirements, in order to also provide the necessary amount of parking and turning on the lot, that the variance would be required to just make those spaces a little bit closer to the rear lot line. And we've again outlined the variance granting criteria responses in our written materials as well. So with that, I'd like to just try to answer any questions you have, and hopefully maybe tap dance a little bit until David Little can be here to answer any technical questions that you might have. Thank you.
Mr. Chairman, are the parking spaces along Southwood Drive, is that the road from the bank parking lot by the hardware store?
It is. It is.
Never knew it had a name.
Yeah.
Are those going to be assigned to the apartments, or are they for visitors and guests?
That's for guest parking.
What was the answer? I couldn't hear you.
Guest parking.
Guest parking.
There's no income restriction on these, is there?
No, these are there would be an ability to put additional units in if they were affordably restricted, but we're not seeking to have that additional number of units.
Let the record reflect that Mr. Little has entered the room.
Thank you, Mr.
Okay.
Chairman.
I have a few questions.
Please.
And I'd like to clarify that the basis for my questions are what's best for the town of Orleans, okay?
Please.
So, who are the principals of New Venture Holdings LLC?
I am. Paul, excuse me, Paul Von Stainsel.
Yeah?
Paul Von Stainsel. I own a building company in town, Cape Dreams Building and Design.
Oh. His name is in there somewhere?
Manager.
Listed as the contract.
Paul is the manager and also the principal and the owner of the company. Paul lives over on Aries Lane in Orleans and raises a family here as well.
Okay. Paul, are there any other principals, or is it just you?
It's just me.
Do you own any other apartments in Orleans, or principal in any?
I own, my previous residence is in South Orleans on Eli Rogers Road.
But they're, is it apartments?
No.
So this is your first venture into apartments?
Yeah, I believe we're actually the first applicants to try to take advantage of the increased density.
And just to further answer that question, Mr. Jevon, Paul was involved in the development of a property in Brewster,
Yeah.
which was on Underpass Road, which was where he built an office building, a small office building with some tradesmen's units for tradesmen to operate, plumbers, electricians, and then that unit actually, I think, had one apartment in it on the second floor.
Right, the office building has one
Apartment on the second floor. So he did develop one property in Brewster that had one apartment on the second floor.
Okay.
So.
All right, that's it. For me.
Just out of curiosity, on Eli Rogers, was it one of the existing homes, or did the subdivision at the end, I knew George, who was the... Okay, yeah.
Deceased former owner, I was just curious.
Right, yeah, our house is the third on the left, so it was previously owned by Patty, I forget her last name. the
Um,
road kind of forks.
Right,
so that-
exactly. Yeah, John's Way is on the corner of the property,
Did
so.
anything ever happen with the parcel at the end? or-
Well, the horse barn was built, and I know that that caused quite an uproar with some of the residents on the road.
Yeah.
We purchased the property right as that was kind of hitting its peak. But we purchased that property in 2006. We renovated the existing building and put some additions on it. And this past year, we built a new house on Aries Lane and then moved the family into there, so. Currently just renting the other property.
Mr. Taub,
In my experience, often when other determinations are required, we're the last to rule on a petition. And I noticed on page 7 of this application that there was an architectural review committee requirement and a site plan review committee requirement and a planning board, et cetera, and that none of those had been approved, if I'm understanding this correctly. And under those circumstances, I wonder under what authority we're proceeding.
We got architectural approval last week. We got final site plan approval today. So I'm not aware of any outstanding approvals that are required other than this.
I think the only anticipation on the bylaws that the planning board would provide advice to the zoning board. I'm not sure whether they've provided a memorandum or any advice, if they have or haven't. We
I
don't-
have not received, and I lament the fact that the file does not include any input from the planning board. At the time of adopting this amendment, that the